Nikki.
Yes, ma'am.
Yes, sir. Very good afternoon to you.
Hi. Good afternoon, ma'am. How are you doing?
That's good, sir.
Okay.
I'm good. How about you, sir?
All good, ma'am. All good. So when can we start?
Now, yeah, within a minute. Yes,
Okay.
start.
A very hearty good morning to all. On behalf of IES University Bhopal, Department of Computer Science and Engineering, I welcome all the dignitaries and participants IES University expert lecture on the occasion of Intellectual Property Rights Day. I would like to extend our heartiest welcome to our today's guest, Kunal Setia. Before we commence with today's program, I would like to present a brief description of IES University. IES has been in the field of education for the past 20 years and has been endorsed as the most promising university of Central India, providing education from nursery to doctor level. IES University is well known for its excellence in overall development-based education of professionals. IES University keeps on taking such initiative for the continuous development of both the student and faculties. We are thankful to Honorable Chancellor, Engineer B.S. Yadav sir, and to our Director, Dr. Sunita Singh ma'am, IES University, for his generous present and who has always encouraged and motivated us by his never-ending hard work, passion, foresight, and vision for the educational system. With this note, I would request Dr. Anita Soni ma'am, Professor, CSE Department, IS College of Technology, to welcome our eminent guest. Over to you, ma'am.
You're not audible.
Sorry.
Yeah, now it's fine. Yeah, continue, please, ma'am.
Yeah, very hard. We are organizing this. Yesterday there was a World IR Day, and related to only we have organized today's workshop. And in that you are one of the part of this workshop, and I would like to extend my sincere gratitude to our Kunal sir, and our Chancellor, Honorable Chancellor, Engineer this platform to can
Hello.
Now, it's my pleasure and honor to introduce our eminent guest speaker for today's lecture. After completing his education of BTech owners, MTech owners, LLB owners, presently he is working as a senior IP attorney and patent agent as a Honorable IP. He is registered patent agent of India and has been working in the IP industry for more than 10 years. Sir has over 8 years of experience during which he has presented several global corporations, small and medium enterprises, as well as setups, companies in protection of their intellectual property, especially patent and industrial design. He has a wide-ranging industrial experience. Welcome to IES, sir. It's a privilege to have your presence in the expert lecture. I would now request you to please commence with the session. Over to you, sir.
Thank you very much for the kind introduction and your words. So I would just like to introduce myself. I'm working with the Noble IP since its inception, and I've been involved with a lot of patent application drafting and design application, prosecuting patent application at the Indian Patent Office, attending hearings on behalf of my clients, and of course advising them on and forth about the inventions, whatever they conceive, whatever idea they have in mind, to convert them into some tangible assets. So I would today what I would like to tell you is about what exactly is intellectual property rights, and from where does this term come from, and why do we need protection of a product, of a process? Is it really important? If yes, how do we protect it, and how as an attorney we can assist you in getting your product patented, or your process patented, or your designs registered, or your trademarks? So let's understand. Can everyone see my screen, please?
Yes, sir.
Okay. So let's understand what is intellectual property rights. It's nothing. It's a human intellect. It's creation of your mind. So you are walking on the road, or you are sitting at home doing something, and suddenly something comes in your mind, and you want, okay, I've developed a product. I want this product to be commercialized in the market. So what do I do? So there you need to create that's the human intellect which you have. That's your particular IP. So that's IP you need it to be registered. So basically, intellectual property is nothing creation of a human intellect. It's a knowledgeable asset, and it's a key component for success in business. So of course, don't think that if you have a product and you cannot file a patent application for it, and there is no business to it, there is no commercialize. Of course there is. If the technology which you're trying to develop really is a substantial technology, if it satisfies all the criteria of novelty, inventive step, of course you can really patent that invention. But yes, there are certain criteria to do it. I'll be discussing that in my further slides. So to protect IPR is to respect your work, respect your knowledge, respect talents, and respect creation. IPR is nothing to encourage technological innovation. So now, you being students of the university, you might be in some engineering studies, or you may be in science studies. Of course, if really you have an intellectual mind, you will come up with a novel process, or will come up with a novel product. Okay, you will go up to a professor and say, okay, I want to protect this. What do I do? So this is how the university also encourages technological innovation and improve IP awareness of the whole society. So I'm here to make you aware of what is intellectual property and why do you need protection for that. So before you begin, you're about to begin with a journey into the world of IP. The presentation will introduce you to strategic value. Now, when I say what is strategic value or the commercial value are two sides of the same coin. So now you strategically develop a product. Now the next question is, can I commercialize that? Do the people should know about my product? Yes, they should know about your product. And that can only be done when you file the patent application, when you conduct a search and say that, okay, my invention is really patentable or not. See, because everything on the planet cannot be protected. There are certain barriers to patent protection. You come up with a process, and the process is very obvious to a person skilled in the art. So don't expect that you're going to get a patent for it. No, you need to show us the technical advancement. What advancement have you done in the patent, or in the product, or in the process, that for which you need protection? So that's really very, very pivotal here. You will learn about the 5 main types of intellectual property rights and the administration. IPO is nothing but the Indian Patent Office, plays a key role in supporting Indian innovation and productivity by delivering and granting quality and timely IP rights. So these days, in fact, the patents are being granted at a very fast pace. I guess in a year or so, you're getting your patents granted if everything goes in accordance what the controller is asking. So if you file the application, file the request for examination and publication, everything, so within a year or so, maximum in 2 years, you'll get a patent granted if it's really unique. Else, of course, there are patent office gives you an objections. You can really overcome those objections. That's not a problem. Now, the 5 IPs are: first is patents, trademarks, copyrights, industrial designs, and one is called a semiconductor and layout design. So you have the IC designs. So you have room for protection for those as well. So for patents, if I talk about insulin process, so these are something which you already know. Let's understand something. For example, the COVID vaccine you have these days. We are still in the pandemic. We have not recovered from it completely. So there are vaccines which have been developed by AstraZeneca, by Pfizer. So do you think they have protected those processes or the product they have? Yes, they have. They have really protected that process of developing that vaccine and giving it to patients. So that process is unique of its kind because it satisfies the novelty inventive step criteria. Trademarks, BlackBerry, Nike; copyrights, Britannia and of Green Gobles, industrial design, and so on and so forth. Apart from this, there are trade secrets, geographical indications, and domain names as well. Now, what are patents? They are new inventions or any new useful improvement of an existing invention. So, as I mentioned earlier, the 3 criteria are novelty, usefulness, and inventive. Novelty means it should be new, first of its kind, first in the world you have introduced. Usefulness, it should be functional, it should be operative. Anyone in the industry can use it. Of course, if it's usable in the industry only, then it's helpful for mankind. Otherwise, there is no use giving a protection for a product which has no use in the industry. Inventive must show ingenuity and must not be obvious to a person of average skill in the art. So that's what I was trying to mention about what is the inventive steps. I'm reiterating, it should not be obvious to a person skilled in the art. So this is just a picture just to show you that when the patent is granted, this is the patent certificate which the patent office provides you, that okay, Mr. X has been granted this patent for his particular work. And the term for a patent is 20 years from the date of filing. So you file your application today, for example, this is 2022. So your patent remains valid till 2042. So you have 20 years of time for the validity of that patent. Of course, once the patent is granted, you need to pay the renewal fees accordingly every year. Now a question comes, what can you patent? Because most of you might be thinking, okay, I have this idea in mind, can I patent it? Okay, let's understand this. So using a door lock as an example, so you have a product that's a door lock. Yeah, you can protect it. You may have a composition, a chemical composition, lubricants for door locks, an apparatus, a machine for making door locks, or a process for making door locks. So all in all, you have a process, you can have a composition, you can have an apparatus, you can have a product, you can have a system, or any improvement of these. So in fact, it's not that you cannot protect something which is an improvement. Yes, you can protect which is an improvement, but it should not be obvious to a person skilled in the art. There should be an advancement to that. So do you really think that all the inventions in the market of which are filed at the patent office are very unique? No. Most of them are merely improvements of the existing inventions, but yes, they show some uniqueness in the form that they are able to reciprocate and convince the controller, saying that, Mr. Controller, this is my invention, this is the novelty part, and this is where I've actually worked the invention. No one on this can actually do what I'm trying to do. It's not very obvious. It's non-obvious in nature. So that is 90% of the patents are for improvement. So according to this statistics, if 90% are improvement, that means only 10% are unique. Is that so? That's not the case. I just want to highlight this thing, that most of the inventions which are there with the patent office, 90% are improvement, but 10 are there which are actually unique, which have been filed by some small SMEs or medium-sized industries or universities or startups. They have very unique ideas on that. So of course they get protection of that 10%. 90% are maybe individuals or some companies who actually work on the improvement parts. So let's take an example that there are generic pharma companies already existing. So they have a known process already for treating a particular patient for COVID-19, SARS-CoV. But is that method really unique? No. So what they're trying to do is they're using that same method, making certain improvement, making certain modifications, and then filing a patent application for it. So that is an improvement. But uniqueness is an invention of first of its kind, which has actually been not done till date. So there is actually uniqueness. But most of the inventions, if you see, according to me, as per my experience, are merely improvements. There is no uniqueness. It's very, very, just on your fingertips, I can tell you that only these inventions are very unique, because nobody must have not even thought of that how this idea has come up. So there you can just find 3 improvement. Use your mouse to find what's different. So see, on the left hand side, the figure says home. So on the right hand side, there is no home. Below, you can see there is a lock. On the right hand side, there is no lock. So you can assume that, okay, I have a product which has a lock. Now I'm developing a product which does not have a lock. Okay, fine. But how you're going to prove that without the lock, your product is giving you efficient results? It's more productive in nature. It's more advanced in nature. It's more giving you economical significance. That is what you need to prove to the patent office. If yes, you're able to prove that, then you will really get a patent for it. But we as attorneys will felicitate you, make you understand that, okay, this is your invention. First, let's understand whether the invention is really patentable or not. What you're thinking is, does it satisfy those criteria? If not, we'll in fact even advise you how you can work around the invention. That, okay, you can try to add this, you can try to delete this. Okay, if you do this, if you do that, maybe you'll be in a position to understand the invention better. So as I said, it's granted for 20 years. So just an interesting statistics to share with you. Not exactly a statistic, it's something which came up to my mind. It's really interesting. That's the youngest patent holder on a wheelchair. So what he did was he created a wheelchair bound 9-year has invented a game of 6-player circular chess. So 6 players can play a particular game of chess. I have in my experience, I've seen only 2 people, or at the max 4 people. I've never seen 6 people sitting at the same time for a game of chess, and that also they're having different platforms to play. So this boy has got the game design patented in his name. So you can see this example before you. It's a multi-purpose waterproof bag device. So it relates to a multi-purpose. When I say multi-purpose, it has more than one purpose, of course. Waterproof bag. It comprises of a canopy mounted on the device for providing protection. So you can see the canopy 9 number. This entire thing is the canopy. Then you have a handle 2. Handle 2 is also there. Just a second. 2 is not ID. Okay. 2 is not given. Associate, maybe it's on the back side. A pocket 3, there is a pocket. Of course, yeah, you can see the pocket here. Then there are Bluetooth earphones associated with the pocket for conveniently carrying the earphones for listening and audio. A lightning unit. So see, you can see how this is how the way the invention is drafted. The claims are drafted. So you have to go step by step. Okay, this is product number 1. This is feature number 1, feature number 2, 3, 4, and you have to number that, and then accordingly you start explaining that. And also remember that whenever you have any kind of product in mind, always try to visualize this as a picture in the form of picture or as a line diagram, because that really helps. It will help you, and it will help us also in defining the invention more effectively. This is again an automated liquid recycling system. Then non-rotating card holding operator. So we need not go deep into that, just giving you a flare idea about how the pattern looks like, how the drawing looks like, how the claims look like, how do you define all these things. So you have to mention how many grooves are there, where is the assembly, how many notches are there, what is the placement of these items, are they really associated with each other or not. So you'll have to explain all these things when you're drafting a patent application. Don't worry, we are there to help you. But my concern is, whenever you get I'm so sorry, whenever you get an idea, just put it in the form as if in a layman language, that okay, this is number 1, this is number 2, this is number 3, even if you have a process. So start explaining the methodology one by one. Just don't mix up everything. Step 1, of course it may be obvious, don't worry on that, but yes, at least you have something in mind, and you have used that mechanism to get the end product. If your end product varies, of course, that is the most distinguishing feature for us, rather than just putting a mechanism which is very obvious and a product which is very obvious. Anyone can do that. So it's better you work on the thing that what is my end result, what is my end objective. So this is just a flare of patterns. Now, what about trademarks? It's nothing a word, a design, or combination of how do you distinguish your goods and services. So we have the car makers called as BMW. We have called Merck. So how do you distinguish a Merck car and Audi car? Just seeing the symbol of that, just seeing the logo of that. So Audi has circles, and Merck has a triangle inside, of course. So not exactly a triangle; it's more of a three-sided three diagonals basically in a circle. So that's how you distinguish McDonald's and all. So how do you distinguish? These are nothing. Trademarks are from the aesthetically. When you see something and you get to know, oh wow, this is BMW. I know this logo. So you know that this logo belongs to BMW. So you're able to recognize that the auto car maker, that this is BMW. Okay, this is Merck. This is BMW, or this is Toyota, whatever it is. And okay, when you see McDonald's, you see Mac. The way Mac is written, that's the way, that's the thing they have protected, right? So it basically distinguishes one organization from the other in respect to goods and services. That's really important. So just to give you some examples, BlackBerry, Nike has a tick sign. So you see, when you see a tick sign, which means it's Nike. When you see Adidas, or when you see McDonald's, when you see Bell, when you see BlackBerry, when you see Nokia, Samsung, Apple, of course, very common. So you see the Apple logo. So this is how you distinguish half Apple. That whenever you see half Apple, okay, this is okay, I know this is from the Apple company. Trademarks can be used to uniquely identify a brand. So brand is, that's what I told, this is the automaker brand. Okay, this is a fast food chain. Okay, I remember this through this brand. Okay, then maybe this is a footwear brand. Okay, this is maybe Adidas, Nike, or Reebok. Then this is a phone brand, Apple, Samsung, BlackBerry. So this is how you recognize things. Now, in today's competitive global market, branding often becomes the most. So branding of your product is really, really, really essential, because if you do not brand your product, there is no use launching your product in the market without any trademark. So tomorrow you come up with a product and you want to commercialize. So you'll ask a question, how do I commercialize, in whose name? So you need to create a logo. You need to create a name. Okay, I'm going to sell this product by the name of XYZR. So R is nothing but your register. So I'm selling this product. So this is my logo. So people will recognize me by XYZ. It provides a proof of ownership. It allows you to flag infringement under the Trademarks Act. It prevents others from adopting a similar trademark. This is really very important. It will stop you. It prevents others. So once you have that brand, you have created that brand, no one else can do it. Even if he does, he's infringing on your trademark, and you need to stop him. It makes licensing your products and services easier. So because the recognition, you get the recognition in the market, you get your branding in the market. This is how trademarks are protected. And it's granted for 10 years, and it can be renewed for the next 5 years. So approximately total life span of a trademark is 15 years. So let's move on to the third, which is nothing but a copyright, which is very common. Rights derived from original, literally, dramatic, musical, and artistic. So you need to remember these four terms: literally, dramatic, musical, and artistic work can be registered. So whatever you write, so let's take example, you have a software and you want to protect the source code. You can't protect it through a patent application. You have to protect it through a copyright. So this is my source code. I do not want anyone to copy my source code. So I'll do it as a copyright. I'll file a copyright application for that. Or maybe you come up with a certain song and you want to protect the lyrics of that song. You can do that through a copyright application. Dramatics, a form of dance, you want to protect that. So any cinematographic pictures or all these things, they all have copyrights, so that nobody can mimic them, nobody can copy them. And even if you do that, you need to procure a license from that copyright owner. If he gives you, only then you're going to use that in your services or whatever you want to do, and pay him a royalty. So that's what the movie stars and all they do. If the films are adapted, if the films, just give me 2 seconds, please. Yeah, so sorry. So when I talk about copyrights, it's nothing but the literally dramatic, musical, and artistic works. From the moment the work is created, the moment you create the work, you are the owner of that particular work. So copyright is an automatic upon creation. The moment you create it, it's yours. You do not need to ask someone that am I the owner of this, or so and so forth. Register your copyright, use proper marking for using your copyright. That is, see, document details of any collaboration in respect of the work. So you have to document each and everything. Okay, and it's something that I'll give you a very good example on that. I have come up with an idea. Okay, an idea maybe I discussed this with you as a source code. Okay, let's go into some other idea. Okay, maybe I've created a song and I want to protect the lyrics of that song. So now it's really not mandatory that the lyrics of that song should be really novel. So my what I want you to understand is copyright. The novelty part is not necessary for a copyright. It is just your creation. That creation can be, you can take it from somewhere and use that and merge certain components and then create a artistic work. You can do that. But what happens in patents is entirely different. There you need to focus more on the novelty and the inventive. So copyright is something, whatever comes in your mind, just draft it immediately. And then, yes, okay, I want to protect it. But you have to document those details. That is really very important. Else, anybody can use it, and then tomorrow the person can claim, okay, this is my copyright. So how can you say that you are claiming that it's your copyright? So these are some copyright works which they have protected. Canadian Geographic, Gregory Charles, and all these, they have protected certain copyright works. So I've given you certain examples. The source code of software, you can protect that. Lyrics of some music of any song, you can protect that. Any literary work, any poems you want, okay, anything which you have written artistically, okay, I want to protect this particular story or something. Yes, you can do it. That's your work. And of course, the life is very long. The life of the author plus 60 years. So you can imagine that work remains with you till even after you die. So that's what I told. Granted for 60 years plus life of the author, and then it can be renewed accordingly. But yeah, the term is such big that there are still copyrights which are existing from last 60, 70 years, and they're still copyright, and people are earning royalty from it. So that's the beauty of copyright. Now comes the most interesting. That's industrial designs, which goes on and along with patents as well, because in patents what you do is you create certain designs or certain drawings of your product, and if you want those designs to be protected separately, you can file industrial applications as well. So you can see the shoe before you. There's a design, there's a particular design of the shoe. Maybe it's in the it's oval from the front, or it's squared from the front, so you want to protect this particular design. So you need to provide us with different views of that design, approximately 7 views: the bottom view, top view, perspective view, left view, right view, side view, back view. So once you provide these design, and you have to also define that, fine, these are the designs, but is there any novelty in those designs? Yes, there should be a novelty attached to it. If not, then there is no point filing that design. Novelty should be there to the finished article, the end product. The finished article is nothing but the end product, how it looks. How is it appealing to you? Is it really giving you a proper configuration pattern or something of, yes, and it has a particular shape? Is the shape really novel in nature, or people have done that? So of course it goes along, as when you conduct a patent search, you have to also search whether there are registered design already existing or not. Same goes with trademark also, that you have to see if trademarks are existing or not, because tomorrow you come up with a logo and you say, I want to protect that logo. The first thing I would say, okay, have you searched that? Do you know any competitors in the market? Are they using the same logo, or are they using the same design or process? If not, let us know. We'll do the search and we'll give you a report on that, and stating that, okay, these are the registered designs already there in the market. So features that appeal to the eye. See, the design must be original, can be 2-dimensional or 3-dimensional. So I love this particular shape of this car, so I really want to protect this particular shape of this car, so this design of this car. So I will file a design application for this. But yes, if there is any mechanism which is improved in this particular car, I'll file a patent application for that. So that's a mechanism which is improving my efficiency and effectiveness or productivity of that particular car. It's not using much petrol or diesel, whatever it is, and it's giving me a better average. Just giving you hypothetically, It may be others as well. Designs such as those features in those products are known for the visual appeal. So it's so appealing. You can see the lamp before you. The way the design has been created, circular, oval shape, it looks at a certain stones kept, and then they have created that marble. Then you can see the design of the glares as well in before you. It's not exactly rectangular. It's a bit curved on the left hand side and on the below portion as well. So these are the appealing things which you should know when you're filing a design application. Then we have the integrated circuit topographies, which is your ICTs, 3D configuration of electronic circuits embodied in integrated circuit products or layout design. So any layout design of any chip you have or any electronic circuit you want to protect it, yes, you can file a separate application for that. But that's very rare. It all depends on person to person, and it all depends on the experiment research which he's trying to do. But I haven't seen any. I've just seen, I guess, 1 or 2 applications which have been filed for integrated circuits till date with the patent office, but I haven't had a chance to witness any of those. So just giving you an idea that yes, if you have any circuits which you want to protect, that you can do that. Used in many technologies, computers is very common, automobiles, pacemakers, cameras, spacecrafts. It's again granted for 10 years and renewed for 5 years. In fact, even design is for 10 years and renewed for 5 years, so 15. So trademark, designs, integrated circuits are all for 15 years, 10 plus 5. Copyright is 60 years plus life of the author. Now, this is something interesting for you. In one product, you have 3 IPs before you. So you can see on the left-hand side, there's a patent, Canadian patent, which displays a handheld computing device, which is nothing with your mobile phone. It includes a display panel, which is 103, a circuit board carrying display electronics for the display, a cover assembly, the covering of that assembly, a resilient layer, a third 2 circuit board for securing the display to the computing device. Okay. Then you have the trademark. So that's a BlackBerry trademark, and they have registered the trademark as well. Then you have the design of this particular phone. Of course, this is outdated, but yes, just giving you hypothetically an example that you can visualize this with any product you have in mind, that okay, this is my product, this can be a trademark for this can be a design for this. So in one product, you can protect 3 IPs. So that's a patent, trademark, industrial designs. At least 3 you can. So you have because you're going to sell that product, so you need a trademark for that. The design is unique. Okay, you file a design application. So the IP behind Kiproxen, it's again a drug, it's a medicine. So on the left-hand side, you can see there is a patent. Bayer is the company, they've protected it for a composition or a formulation, right? And for trademark, it's Cipro. The way it is being marketed in the market is that it's a registered trademark of Bayer. So they are selling this drug, selling this medicine by the name of Cipro, and this is how people recognize Cipro. Okay, this medicine is Cipro. Okay, this is for this. The similar way as you see people are very common about Dolo. So when you see Dolo 650, when you take out that medicine, it's written Dolo. So which means, okay, people are recognizing that Dolo, but most of them even do not know what is the salt in that. Of course, after COVID, everyone knows, but before COVID, no one knew what is Dolo 650. I, as a person, got to know many people who said that, okay, what is Dolo 650? I really do not know. I said, it's nothing, it's a paracetamol. Oh, really? They were very surprised. Okay, it's paracetamol. We did not know. But the way pandemic came and is still there, so people have, whenever you have fever, so you start taking paracetamol, but you did not recognize it. Why this Dolo 650 is really very common? Because the company is selling this in such a way that it's selling it as a cheaper price, and it's doing its branding. It wants people to recognize its brand, Dolo 650. So that's how it's in your head now. Dolo 650. That's the medicine. But people do not know what it actually contains. They just want, okay, it relieves my fever. Okay, fine, that's it. Now, benefits of doing IP searches, as I mentioned, where we conduct a patent search, we do a design search, we do a trademark search. So why it's beneficial? It identifies trends and new developments. It generates new ideas, gains competitive intelligence, licenses new products, solves your problems, and identifies manufacturing. Manufacturing partners are your competitors or players which may be of interest to you, who can commercialize your technology. See, because for tomorrow you develop a product, you do not have funds for that. What do you do? So we are there to commercialize your IP, find out certain stakeholders in the market who can actually commercialize your invention, who can take your invention to the market, manufacture it in their warehouse and then sell it. So that's they can do. So this is all about intellectual property. Just to give you a brief idea about what is intellectual property all about, and what are the different types, how do you protect that, what is the term, giving you some hypothetical examples as well. Yeah, so now I'm open for questions. If anyone has any questions, please feel free to ask. Hello. Yeah.
Yes, sir. It's a very nice presentation, sir.
Thank you.
Really, it's very nice. Sir, you're working, means if I will give you any topic, then you are able to do the patent for me. Like that, you are working? You are working as a private agent. It was written in your resume. That's why I'm asking with you.
No, I'm associated with Ennoble IP.
Okay.
And whatever you give me will go through Ennoble IP. And like, for example, if you come up with certain inventions, so we will share a disclosure form with you. You fill that form and then we take it forward.
Okay. So for patent, I will contact with you, sir.
Yeah, of course you can do that. You can contact me or my team. Of course, you can write an email to us and then we'll connect with you.
Okay, sir. Thank you, sir, for this valuable and informative session. On behalf of an IS group, I, Anita Soni, would like to conclude this session with a vote of thanks. I hope you all enjoyed this eminent lecture. It was really an engrossing and fruitful session. On behalf of an IS University Bhopal, I would like to thank to our guest speaker, Mr. Kunal Sethi, for her wonderful and informative session. I would also like to express my deep gratitude to our Honorable Chancellor, Engineer V.S. Yadav sir, for his never-ending encouragement and guidance to organizing such a session. And I also like to thank all the team members, Nikita ma'am, Ankita, and all. And all I would like to thank to those who are connected, join this session and make it fruitful. Thank you, sir. Thank you, sir. It's really very wonderful. Thank you. Thanks a lot.
Thank you to one and all. And in case if you have any questions with respect to your inventions and other, please feel free to connect to us. Yep. Okay. So I'll share the contact details. Of course, Kushal from my office, he'll get in touch with you. In case if you have any kind of work, for example, if you have come up with certain ideas or something, we will share the documents with you and then you can take it forward.
And for that, how much I have to pay?
No, that is as per the university norm. Whatever it's confidential because I really do not know. There's an agreement between the university and the company, and accordingly, we'll be reimbursing that amount.
Okay, sir. Thank you, sir. I will contact with you, sir. Thank you. It's a very nice and fruitful presentation by you.
Thank you, ma'am.
Thank you, sir.
Okay, bye-bye. Take care, everyone. Bye.
Bye, sir. Bye.